Hello everyone, this is your host Urvashi Chauhan. Welcome to Courts Today by Livelaw, your one-step destination to all legal developments in the country. Let us start. A vacation bench of Justices Dipankar Datta and S.C. Sharma of the Supreme Court today heard the application seeking uploading of Form 17C data on the Election Commission of India website and publication of booth-wise voter turnout data. The interim application has been filed by NGO Association for Democratic Reforms, that is ADR. The main writ petition has been filed by Trinamool Congress leader Maua Moitra in 2019, alleging discrepancies in the voter turnout data of the 2019 general elections. The Election Commission has opposed the application, stating that there is no legal mandate for general public to access Form 17C. That as per the conduct of election rules, Form 17C can be given only to the polling agent of the candidate. The Election Commission also said that uploading of Form 17C on website can lead to mischief and confuse the voters, leading to mistrust in the process. Senior Advocate Maninder Singh appeared for the Election Commission and questioned the maintainability of the petition filed by ADR on the ground that the issues were covered in the judgment in the EVM VVPAT case which was delivered recently. He stated that the figures in the voter turnout app are tentative as they are based on secondary sources. He also refuted ADR's argument that there was a variance of 6% in the final data from the figures published. He cleared that the variance was only 1 to 2%. Senior Advocate Dushyant Dave, appearing for ADR, refuted Singh's submission, saying that EVM VVPAT case covered a totally different aspect as it pertains to the post-counting situation, while the present application is regarding the pre-counting stage. To the bench's question as to why did the petitioner not bring the issue before date of notification of the election, or why no steps were taken to get the matter heard for 5 years, Dave replied that the cause of election for application arose only when the Election Commission made the disclosures regarding the voter turnout. But the bench expressed reluctance to interfere in the middle of the election process. It said that a hands-off approach has to be taken by the court regarding the election process and that there cannot be any interruptions in this process. Senior Advocate Abhishek Manu Singhvi, appearing for Moitra, also said that there are nearly 10.37 lakh Form 17C records in all 543 constituencies. If the total forms are divided by the number of constituencies, the number per returning officer per constituency, the figure will come to 1911 forms, and thus it was manageable. However, the bench expressed its reluctance to interfere at this stage. The bench also pointed out that the prayers in the interlocutory application were same as the prayers in the main writ petition filed in 2019. The bench stated that the main relief could not be sought in an interim application and suggested that the application be heard along with the main petition. The Bharatiya Janata Party has now approached the Supreme Court against the Calcutta High Court's order which restrained it from printing certain advertisements against the Trinamool Congress which are derogatory and violated the Model Code of Conduct during the Lok Sabha elections 2024. The SLP filed by the BJP was mentioned today before a vacation bench of Justices Bela Trivedi and Pankaj Mittal for urgent hearing. The counsel, explaining the urgency, stated that an ex parte order was passed against the party which was to be enforced till 4th June. However, the bench expressed disinclination to consider the matter today. BJP leader Suvendu Adhikari has approached the Calcutta High Court flagging illegal raids being carried out on his and opposition leaders' properties by the West Bengal police on instruction of the ruling TMC government to allegedly influence the elections. The West Bengal police has been investigating complaints of firearms and large sums of cash allegedly found at the residence-cum-office of BJP leader of opposition Suvendu Adhikari, which was in the name of his personal secretary. The counsel appearing for Adhikari argued today that he was given protection by the High Court in the present matter and that the police were targeting the property held by his personal secretary, which he was using as his office and residence. It was stated that he was being targeted in order to influence the ongoing Lok Sabha elections. Counsel for the state submitted that the order for no coercive action was granted only against Suvendu Adhikari and not his aides. that the premises in question were not in Adhikari's name and he was not involved as an accused or witness in the present case. Thus, he could not approach the court through such a writ petition. After hearing both parties, the single bench of Justice Amrita Sinha restrained the West Bengal police from investigating complaints of firearms and large sums of cash till 17th June based on a coordinate bench's order which had directed that the state police would need to take leave of the court before taking coercive steps against Adhikari in connection with the present cases. The court held that since elections were slated to be held tomorrow, the police's investigation could be stayed till the reopening of court after summer vacations. The Supreme Court today stayed the Uttarakhand High Court's order asking the state government to find a suitable place to shift its premises out of Nainital. Let me tell you, the High Court, through its full court resolution of September 2022, had resolved to shift the High Court from Nainital. The court had stated that shifting the High Court from Nainital was necessary due to several reasons: the larger public interest, difficulties faced by litigants and young lawyers, inadequate medical facilities and connectivity, and the high costs for the state government, which is involved in over 75% of the cases and has to spend a significant amount on travel expenses. Challenging this order, the High Court Bar Association of Uttarakhand moved the Supreme Court. Solicitor General Tushar Mehta, appearing for the state government, submitted that the High Court's order was a kind of referendum. Senior Advocate P.B. Suresh, appearing for the Uttarakhand High Court Bar Association, argued that it was only the Parliament or central government that could decide on the establishment of a principal bench and not the High Court. The bench of Justices P.S. Narasimha and Sanjay Karol heard the matter and issued notice on the SLP and sought the state government's response. The matter is now listed after the vacations. Stay tuned. In another update from the Calcutta High Court, it has temporarily stayed an investigation by the West Bengal Police against the officer on special duty to the governor and other Raj Bhavan staff members who were accused of wrongful restraint by a former employee. This former employee had accused the governor, C.V. Anand Bose, of molestation. The petitioners, that is the OSD and other staff members, sought to quash the proceedings and the FIR against them. According to the complainant, she had been restrained in a room of the Raj Bhavan where the staff members attempted to take away her bag and phone and warned her against raising her voice against the governor. The Advocate General for the state argued that there were two distinct offences: one of molestation by the governor, which could not be investigated due to his immunity, and another of wrongful restraint by his staff, which was being probed by the police. It was argued that there was no absolute restraint of the complainant, who would be required to prove the charge since she was able to get out of the Raj Bhavan premises and file her complaint with the police. It was also stated that Article 361 provides absolute immunity to the governor and that implicating the staff members was a way to indirectly challenge that immunity. The bench of Justice Amrita Sinha held that to prove the offence of wrongful restraint, complete restraint would need to be shown, which was absent from the present case. It stated that since the complainant was able to move freely, the allegation of wrongful restraint could not have been completed. The court stayed the investigation in the matter till 17th June. Artificial intelligence is slowly becoming an integral part of our daily lives, influencing various sectors such as healthcare, finance, education, and now even the judicial system. AI's ability to process large amounts of data quickly and provide insights has made it an invaluable tool for improving efficiency and decision-making. In light of this, let me tell you, the Manipur High Court, in a remarkable development, has employed the use of artificial intelligence to conduct research into a service law matter and passed a recent order. A single bench of Justice A. Guneshwar Sharma was dealing with a matter concerning the Service Conditions Village Defence Force or VDF. While the court had called for an explanation from the Government Council on procedures for disengagement of VDF personnel, but it did not get a response. The court was compelled to do extra research through Google and Chat-GPT 3.5 to collect important information regarding VDF. With the research, the court came across an office memorandum on the service conditions of VDF personnel, as well as an earlier decided case which dealt with a similar subject matter. In this case, let me tell you, the order of removal from service was issued on 2nd January 2021. That is, the day on which the accused had escaped from police custody without giving him an opportunity of hearing. The inquiry was conducted only on 8th Jan, where some of the regular police personnel were awarded with minor penalty, but the petitioner was awarded a major penalty of removal from service without any show cause and inquiry. Thus, the High Court has now set aside the order of disengagement. The Kerala High Court has declined to impose death sentence upon Nino Matthew for the double murder of his accomplice and lover's daughter and mother-in-law. Nino Matthew and Anu Shanti came in a relationship while working together at an IT company in Thiruvananthapuram. They have been convicted for conspiracy and murder of Anu's 3-year-old daughter and mother-in-law in April 2014. Nino was awarded death sentence and Anu was awarded life sentence by the Sessions Court for committing the offence of murder. The division bench comprising Justices P.B. Suresh Kumar and Johnson John was considering appeals against their conviction and Nino Matthew's death sentence reference. The court has converted the death sentence imposed upon Nino Matthew to life imprisonment and ordered that he shall not be entitled to remission for a period of 25 years. Also, appeal preferred by Anu Shanti has been dismissed, confirming the life sentence imposed upon her by the Sessions Court. And lastly, the Delhi High Court has refused to direct the Bar Council of India to treat the degree of a law graduate from the University of Hertfordshire in United Kingdom as equivalent to an undergraduate course in India. Justice C. Harishankar said that the court could not direct the BCI to provide any such certificate of equivalence. It said that equivalence is a matter for academic bodies to decide, and courts cannot declare courses of study or institutions from which such courses are undertaken as equivalent to others. With this, the court disposed of the plea moved by a law graduate seeking a direction on BCI to equivalent his degree as a 3-year graduation course in India and to allow him to take admission to a 3-year LLB course. But the court did direct the BCI to take a reasoned and speaking decision on his representation within 3 weeks. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Livelaw. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.